Good afternoon, everyone. Welcome to today's lecture with the Institution of Mechanical Engineers on legal tools for innovators. Before we get to the heart of the lecture, just a few quick things. There is no scheduled fire drills today, so if you hear the fire alarm ringing, you know where to go because we've not got anything scheduled. I'm also pleased to introduce our speaker for today, Gregory Carty-Hornsby. Who is a patent attorney qualified with the UK and the European patent offices. He's also spent time in Hong Kong, where he's worked with the patent department of a large manufacturer of power tools for garden products. Now, before becoming a patent attorney prior to this career, Greg worked for an engineering consultancy in Cambridge in the field of medical devices. And Greg also has an MEng degree in mechanical engineering from the University of Birmingham. Now, before I hand over to Greg, I would also like to let everybody know that they can ask questions throughout the event via the chat window, via Ask the Question feature, which is available on your screens. Now, without further ado, I would like to pass the virtual floor over to Gregory Carty-Hornsby. Greg, you're on.
Thank you, Ram. Thanks for that introduction. Well, let's get cracking. As Ram said, I'm a patent attorney, although I have a background in mechanical engineering. Patent attorneys, we all tend to have a technical background of some variety. So I am, of the same kind of schooling as the inventors that I will speak to on a daily basis. Just some background about the firm that I work for. We're called Marks Clerk. We're intellectual property specialists. We're a very old firm. One of the founders, Dougald Clark, he invented the two-stroke petrol engine, which I think is quite interesting from a mechanical engineering kind of perspective. He also did that to avoid the patent that Otto had managed to get for his four-stroke version. So clearly an illustrious history in the mechanical fields for our firm. We've got loads of offices around the UK. There'll be one in your area. We're also an international firm too, and as Ram said, I was fortunate enough to spend some time in Hong Kong last year at our firm's office over there, working with their clients. But you've not come to hear about my firm. You've come to hear about the world of intellectual property and how that can help innovators. So we're going to start with a brief overview of what intellectual property is. We're going to run through the key intellectual property rights. I could talk for a whole week about these different things. There's a lot of material to cover, so you'll have to forgive me that we may have to go through the slides with a fair pace, and it might be quite high level. But if you do have any questions, please feel free to put those in the chat bar, and we can hopefully have time to talk about those at the end of the presentation. Once we've done these rights, we'll have a look at how these can help innovators. And if we have time, we'll talk about a small number of changes that are going to come in at the end of this year due to the Brexit transition period. So, first slide. What is intellectual property? Well, from a very high level, intellectual property is a set of legal rights that protect intangible ideas and creations. So, taking an example, think about a book. Now, the property rights associated with that, you can own the book itself. You can own what you're really owning there is a copy of that book. But the book also contains lots of other types of property in it. There are the concepts described in the book, there are the characters in the book, even the typeface that's being used, the specific wording and language in the book, the cover art. Those are all things that exist outside of that one copy of the book. Just because you own the copy of the book doesn't mean you own those other things. So you can see that we need something that's an intangible, something to protect the intangible elements of this book to ensure that the book's author and the people who produced it are able to profit from their intellectual creation. In general, IP rights have a number of things that unite them all. So pretty much all IP rights are negative rights. This means that you can use them to stop other people doing something that you created. What it doesn't mean is that they give you a right to actually do something. So a good example, going back to the book, would be Harry Potter. You know, I could write my own story about Harry Potter, but that doesn't mean I own the character Harry Potter. J.K. Rowling owns that. So J.K. Rowling could stop me from using her intellectual creation because she has copyright that protects it. But the precise story I invent with Harry Potter, perhaps he becomes a patent attorney, you know, I would own the intellectual property in that. So you can see how it's a negative right that can stop people. It doesn't give you the right to actually do something. IP in general as well is territorially limited. So it covers only a specific geographic area. We don't have a universal worldwide system for all IP, though we do have lots of international agreements in place. And the final point about IP that unites all the different rights is that they tend to be time limited. So in return for getting your protection, once your time is up or you stop using your protection, your creation becomes free to everyone. So a good example here is perhaps the song Happy Birthday to You. Everyone's aware of American TV shows singing For He or She's a Jolly Good Fellow. And the reason for that is that there's copyright on the song Happy Birthday to You. Well, that copyright has expired in some countries. It will expire in other countries soon. And so in the future, we might start seeing TV shows singing that song because they'll be able to now, and they won't have to pay the author any money to do it. So from the perspective of an innovator, then, what are the main types of intellectual property? Well, first and foremost, there's patents. So that's the thing in the top right-hand corner. Patents protect functional things. They protect principally inventions, things of a technical nature. Apart from patents, we also have designs. So designs protect the aesthetics and style. The example here is the bottom left-hand corner, which is clearly an iPad. Think of the design as protecting the outside of the iPad and the patent as protecting everything that's inside the iPad and how it functions. Then we have copyright. Copyright can protect all sorts of different types of creations, but principally it protects against the act of copying. And then finally, we have trademarks, which are still extremely relevant to innovators because these protect your commercial identity and help you protect your reputation so that you can bring your superior products to the market and prevent counterfeiters. So let's move on to patents, which is closest to my heart because it's where I do most of my work. As I said before, patents protect inventions. They protect things of a technical or functional character. It could be a new method of doing something. It could be a new widget or a bit of gubbins. It could be a chemical formula, a vaccine. There are certain exclusions to patent protection. So you can't get a patent for things that are discoveries, business methods, games. A computer program running on a computer wouldn't attract patent protection, so something like just a normal game. But a computer program that had some kind of technical effect outside of the computer might do. So you can get patents that protect software that runs advertisements or how to run display boards and things like this. There's also ethical exclusions, so you can't get protection under a patent for methods of treatment or diagnosis practiced on humans or animals. That's to prevent doctors and vets from being sued, but the tools that the doctors and the vets will use could be protected, so the drugs and the surgical equipment could be protected by patents. And then the final, probably the most important point about a patent is that you need to meet certain basic requirements. And principally these are that your invention needs to be new, it needs to be different to everything that came before it. But that difference also needs to make a difference. So you need to have an inventive advantage. You can't just do something in a routinely different way. You need to be doing something that builds upon and improves upon the scientific knowledge that's out there. So I should have mentioned at the start, but we're going to do a few true or false questions in this, maybe bust a few myths along the way. So here's the first one. If you were to write a complete description of your invention and get it countersigned and dated, you have protected the invention. Well, the answer here is it's false. The key point is that a patent requires an active step on behalf of the inventor. You need to write something and file it at a patent office. It's still important that you keep descriptions of how you developed it, because you might need later on to prove that you actually came up with the invention. So how do I do that then? How do I get my patent? Well, your application is a written document, and it should contain a detailed description of the invention. It should contain some drawings of the invention, if applicable, so you can see this funky shoe thing on the right-hand side. The most important part of the patent is that it needs to have a set of claims, and these are sentences that simply describe what the scope of protection sought by the patent is. It's basically like a small law that you write, that the patent agent writes, that delineates the scope of protection that you seek. So in this case, it could be a shoe comprising a spring, to make the wearer presumably a lot less stable. Once you've done that, once you've written your patent application, you then need to file it. So you can file it, for example, in the UK, at our patent office. You could file it at the European Patent Office. I hear this quite a lot. Patents always leave out important parts of the invention, so competitors won't know how to make it work. This is false. You can only get a patent if you tell the world how it works. That's part of the bargain that you enter into with the government. In fact, if you don't fully disclose how your invention works, your patent won't be valid. Particularly in the pharmaceutical and chemical fields, this is a real issue. You need to make sure that other people can replicate what you did, that they can build upon the knowledge that you are being rewarded for in your patent. So what other things do you need to do when you're getting your patent? Well, after you've filed it, the patent office will do some searching, and they'll try to find prior art, which is basically anything that was published before you filed your patent application. Once they've found their prior art, they'll look at your claims and they'll decide whether your claims are new and whether they are inventive over that prior art. They'll also look at whether you've sufficiently described your invention, as I just mentioned in the last slide. And there's some other minor requirements, like your claims have to be read so that they're written clearly. 9 times out of 10, the patent office will have some kind of objection. So they'll send you a letter, and in response, you can argue back and say, no, your objection is wrong, or you could do something like amending your claims to try and avoid what the prior art discloses. So it's a bit of a back and forth process to get the patent in the end. True or false? If you need international patent protection, you can get a world patent. Well, again, this is false. There's no such thing as a world patent. As I said earlier, patents are territorially limited. Each patent basically provides protection in a single country. We do have something called an international patent application. Now, that doesn't result in a worldwide patent, but it does tie up the early stages of the patent application process for 150 countries in the world. So all those countries in blue on the top right picture, you can file centrally at the World Intellectual Property Office and deal with the first 2 years of the application in one place. After that period is over, you then need to convert that patent into national patents in each of those individual countries. So you still need to eventually choose where you want protection, and you'll still need to speak to those countries' patent officers, but you can do the first step of the process in a central place, which is good to give you more time to figure out where you actually need your protection and keep all these options open to you. In Europe, we also have the European Patent Office and the European Patent Convention. Now, this is nothing to do with the EU, so it covers all of the countries you can see on the bottom right there that are in green, so it's more than just the EU countries. This is more than just what the PCT provides. This is a centralized system for granting patents in Europe. So the European Patents Office will look at your application, they'll do that back and forth with you, they'll agree with you what your scope of protection could be, and when they grant the patent, you instantly get given a patent in all of those green countries. So it's a bundle of national patents. Now, once you've got to that stage, you'll need to do certain steps to keep it in force in those countries. So certain countries like Poland require that you'll have to translate the application into Polish. In the UK, we're happy for it to be in English, French, or German. So there's extra steps that you need to do. But in principle, you could end up with 35 different patents just off the back of one central application. So the next question then. Someone else can't get a valid patent if you thought of the invention first. Well, again, I'm afraid this is also false. The key part here is the bottom bullet point. So it's the first person to file who gets the patent, not the first person to invent it. So you've got to take that active step. If you don't take that step of actually getting your thing on file, then you might lose out to someone else who does it independently of you. It's important to consider the effect of patents that are held by other people. So a good example of this is that your invention could be an improvement to an earlier invention. Well, that earlier invention could still be under patent protection. So as well as coming up with your own intellectual property, your own inventions, you should also consider rights that might be held by others. So we often do an exercise called freedom to operate searching, where we look for patents held by competitors of our clients. We go through those and we try to see if what the client is proposing to do could be something that infringes the claims of those patents. These can be useful to avoid disputes. You don't want to find out that you've already made your product and have been selling it and you infringe a patent. It allows you to design around the patents that are out there, but it might also give you an opportunity to apply for your own patent protection to the improvement and then kind of offer that to the original patentee in a cross-licensing arrangement where you say, look, I need your patent to work my invention, but I'll let you use my improvement, and then we can both sell these products in this space. The next question then. Once I've applied for a patent, I can mark my invention patent pending to warn others. Bucking the trend here, because this one's true. You absolutely should mark your product as patent pending. You should also include the application number, or you should make sure that you can find the application number on your website. It can be a great marketing tool. It shows people that you're taking your IP seriously and that you are developing new technologies. It can act as a deterrent. But one key consideration here is that if your patent application dies or it's refused, you need to stop marking your products as patent pending, because to do that without a patent in the pipeline is actually now a criminal offence. So you should definitely do it, but you need to make sure that you're doing it right. So that's a very high-level whirlwind tour of the world of patents. We now move on to the world of designs, which is actually quite a complicated area of the law. Principally, designs protect the way that a product looks. So it protects features such as shape or configuration, colors, materials. It has some exclusions. It has things that you can't protect, such as technical function, features that must fit with one another. So you can see it's really directed towards the aesthetics of the object. Similar to patents, you need to have some certain basic requirements. So it needs to be new, it needs to have individual character, so it needs to be a different overall impression to what came before it. And where the kind of legal complications come in is that there's two types of design registration and two legal regimes that cover the UK. So we have registered designs and unregistered designs, both domestically and at EU level. So I'll talk about the kind of things that those rights cover in a second. If you publish your design or do some test selling, you can see how the market reacts, and if it is favourable, you can register the design afterwards. This is true, but only for designs. So the big health warning here is that if you did this with a patent, you would terminally kill your ability to get a patent for it. But for the world of designs, you're given a 12-month grace period in the UK and the EU from your first publication before you need to get your design filed. So that can give you some time to see what the market's doing and how it reacts to your product. This doesn't protect you, however, against third parties who file their own design that might cover yours. So the bottom line is that you still should be filing as soon as you can, but it does give you more leeway in the world of designs to kind of test the waters. What are you filing then? So if you're doing a registered design, you need to file it at a intellectual property office, the UK Patents Office, or the EU Intellectual Property Office. What you file is a series of representations. So the top picture here for an air spraying canister, you file 7 representations, and it will protect against any product that produces the same overall impression as what you display in your representations. But only if your design is new and has individual character, as we discussed on the previous slide. Once you've registered it, it lasts quite a long time. It can last up to 25 years. I should have mentioned earlier, but comparatively, a patent only lasts for 20 years. Designs are also very cheap compared to patents because there's no thorough examination. There's no back and forth to find out whether your design is new and has individual character. You basically just get given it. You figure that part of the process out later on if you ever go to court with the design. So they're very cheap and cheerful. You can get a registration number, and they can be a powerful marketing tool and a powerful deterrent in the same way that a patent is. Talking about unregistered designs then, obviously the key difference here is that you don't need to take any steps. They arise automatically just because you started selling your product. They last, however, for a much shorter period of time. In the EU version of the right, it's 3 years. The UK has a 10-year version of unregistered design rights. But the biggest limitation for unregistered designs and why you shouldn't rely on them solely is because they only protect you against people who have copied you. They don't protect you against works of an independent genesis. So if we came up with 2 designs independently of one another, and we can't establish a causal link that I copied you or you copied me, we're both free to inhabit the same space in the market. So it's a slightly higher bar than for a registered design or for a patent, because those 2 rights protect against anybody who falls under the scope of the claim or produces the same overall impression as the representations. So it is much narrower protection under registered designs. So we move on now to the issue of copyright. Now, copyright's an interesting one because in theory, copyright can cover anything. It applies to any intellectual creation that reflects the personality of the author. So this can be classical things such as paintings, sculptures, etc. It can also be computer software, so the actual coding that you write into the software. It can be things like databases. From an innovator's perspective, particularly from a mechanical perspective, it covers your engineering drawings. There have been recent decisions at the European Union level from the courts there that have said that it might even now protect functional objects themselves. So the Brompton bicycle, for example, was found to have been able to be protected by copyright, whereas that wasn't the case until a few years ago. Another myth to bust. You can only get copyright protection if you register your copyright and you mark it with the copyright symbol. This is false. So in the UK, copyright protection arises automatically. You don't need to take any actual steps to get it. You also don't need to use the copyright symbol, but we generally recommend that you do that because it tells other people that you are reserving your rights in that particular work and that you intend to enforce your rights. If you don't put the symbol up there, there might be an underlying assumption that says, oh, you're kind of giving this to the world. So it's always worthwhile making sure it's clear. And you'll see the copyright symbol at the bottom of these slides, for example. So we do recommend that you use it. Copyright is by far and away the longest lasting type of IP. It lasts until the end of the calendar year in which the last author dies, plus 70 years. This slide is incorrect. So all of those songs that were written by John Lennon and Paul McCartney, that 70-year period hasn't started rolling yet because, one of the authors is still alive. I imagine Paul McCartney has incredible health insurance for that reason. There's no validity requirement for copyright. You're always going to get it, so it comes into existence, automatically. But in terms of the protection that it can actually provide you, as it says in the name, it only protects against copying. There's no protection against things of an independent genesis. So you have to establish an extra causal link that not only is someone producing something that looks like your thing, they knew about your thing before they started making and selling that. So you need to kind of get over that extra bar that, you need to prove that they knew about it, which does make it quite a limited right. Finally, then, we move on to the issue of trademarks. So trademarks are very important for innovators because they protect the company that you work for. Innovation is inherently a business proposition. You're doing it because you're trying to go to the market, improve products, make a profit off them, and you need to make sure that you are protecting your reputation when you're out there, and you want to make sure that people aren't providing goods to the market that say they're from you that have an inferior quality. So trademarks are here to protect commercial identities. They protect anything that consumers can use to distinguish two commercial entities from one another. So good examples, logos, names, obviously, but things like jingles, everyone's familiar with the Intel jingle. Things like colours, the particular colour of green that BP use on their petrol stations, but also more abstract things. So shapes are something that you can protect. The bottom right picture there is a Weetabix. Now, that shape of the Weetabix is actually a trademark. And if you open a packet of Weetabix, or you open a supermarket home brand version of a Weetabix type cereal that is that shape, it will say on the underside of the flap that this is protected by trademark number blah blah blah, because that's a very important part of the business to Weetabix. You can also protect things that are even more abstract. So you can protect things like smells using trademarks. The smell of freshly cut grass was trademarked for the sale of tennis balls. The type of protection that you get under a trademark is limited to different classes of goods and services. So you don't just get protection for the use of the mark in any context. For example, the Apple logo. Apple will obviously have that trademarked in the world of computer electronics, devices, phones, etc., etc. But they won't be able to get a trademark for that in other areas. So you could use that logo if you were a seller of apples, for example, because I assume that Apple won't have actually trademarked it for food sales. So it doesn't cover everything universally. Similarly to the situation we had for designs, there's actually two versions, registered and, in inverted commas, unregistered trademarks, and we have them at two levels in the UK. So you have UK only or EU-wide trademarks, the difference being where you apply to register it. So taking a look at the registered trademarks first, you get these by applying at an intellectual property office like you had to do for your registered designs and like you had to do for your patents. You need to meet certain basic requirements again. One of those is that you need to be distinctive and not descriptive. So a logo of an apple or the name Apple, when you were selling groceries such as apples, would probably be deemed to be too descriptive. But it would, as we've established, be a good trademark to have in something unrelated to what it actually describes, so in the world of consumer devices. You also need to have an eye on who else is in the particular market that you're in. So your trademark needs to be different, and it needs to not be confused with an earlier mark in the same goods and services. So a good example of this is that about 10 or 15 years ago, Asda were selling their own brand of biscuit called a puffin biscuit, which bore more than a certain similarity with penguin biscuits. It's a similar sounding word, it's a similar looking bird, they're both black and white. And so Penguin took Asda to court and said, look, this is clearly trademark infringement. That you're likely to confuse customers here. So that's the kind of protection that trademarks provide you. You can't use them to cover. You must use your trademark to distinguish between goods and services of different companies. You can't use a mark that's likely to confuse the customer. There's no term limit on trademarks, so they renew every 10 years. The trademark will be lost if you don't use it in a 5-year period, though. So there still is a bargain that you enter into with the government to say, look, you're going to keep using this mark in return for the government allowing you to trade under it. And I've kind of already discussed this final point, but the protection is things that are going to confuse customers. So if it's an identical mark or there's a likelihood of confusion, then you'll be able to use your trademark to stop other people selling goods and services underneath it. The final thing to consider is unregistered trademarks. So actually, there's no such thing as one of these. But what we do have is something called the law of passing off. Now, that is similar to what we described with registered trademarks. You obviously don't need to do anything, but it's a relatively high bar to prove. You need to prove that you've got goodwill in your company, that you've been trading for a number of years, you've got a good customer base who like you, and you need to prove that someone else has tried to duplicitously associate themselves with you, with your brand, and that other person is trying to say that the goods that they're providing are associated with you somehow when they're not. The way that you can kind of distinguish whether or not something is a registered trademark and an unregistered trademark is whether it has the R symbol, as we had in the previous slide, or whether it simply uses the initials TM. The initials TM denote the fact that the proprietor might be wanting to register that trademark in the future, but really it means that they're relying on the law of passing off until, as of such point, that they do register their trademark. It might be the case they couldn't get a registered trademark for what they're selling because it might be too descriptive. You see this a lot with paint colours. Some paint colours have a registered trademark, but many don't, because if you're trying to register the word light blue for a light blue paint colour, it's obviously too descriptive. So the final step of this overview is, how does all of this help innovators? Now, I hear these kind of things all the time. I hear my products aren't good enough to attract any IP. In my industry, someone else has already beaten me to it. Someone else is already doing it. We're followers, we're not leaders. We're playing catch up. Our stuff just isn't good enough. Or even that nobody in the market that you're in bothers with IP protection. Well, all of these things, in my view, and I would be biased towards this, I think are a nonsense. It's really, really important that businesses and innovators get to grips with the IP that they're generating. As you've seen, there are types of IP that you have to take active steps for, but you're probably, as an innovator, just accumulating a load of IP naturally anyway. You're going to be getting unregistered protection on designs. You're going to be attracting copyright. You may even be establishing unregistered trademarks. So it's really important that businesses take a stop and take a moment to realize what they actually have at their disposal. IP can help you, because if you've discovered a new market, a new type of product, you can use a patent or a design to try and lock other people out of that and have that market to yourself. If you are promoting a physical thing, you can use your designs and your trademarks to prevent copying. You can stop knockoffs reaching the market. Your trademarks, as we said, will help protect your identity to ensure that people associate you with a highly reputable type of product. Think of the reputation that Apple has, for example. They spend a fortune preventing other people from using their trademarks because it's so important to them that their logo and their branding is synonymous with quality. And finally, even if you've applied for a patent or you've got a design or unregistered rights in something that you're not using, that might give you some leverage. You can license those out to other people, to other companies that might be able to use it, and just take some royalty fees off it and earn some income off that. You might end up getting protection in 3 or 4 different countries and then decide that it's too difficult for you to do business in one of them. And so you can license your IP in that country, that one specific country, out to someone else to use. So you can use them to passively generate income too. So for me then, I think IP in general are a really important set of tools that innovators need to be aware of and need to get to grips with, because they can really help accelerate the growth of your business and help you create more products and new things that are going to come to the market to grow your company and to carry on your engineering, your innovation journey. Now, we do have some time. I've managed to get through those slides a bit quicker than I anticipated. So apologies if it was a bit of a whirlwind, but we should at this point also take a moment to talk about the effect of Brexit. Now, as I mentioned, some of these rights that we discussed are to do with the European Union, and a lot of them are not. So patents, for example, are nothing to do with the EU. There was an effort to try and get an EU-wide patent, but it never came into existence. Copyright, again, was nothing to do with the EU. There's a few legal decisions that are on their way through the courts in the EU that after Brexit, they will still come in and have an effect, but it's going to be relatively minor. So there's no change here to patents and copyright. But at the end of this year, the Brexit transition period is over. And that means that as of the 1st of January next year, there will be big changes to designs and trademarks. So principally, the EU level rights, so the EU community designs, registered and unregistered, and EU registered trademarks, they will no longer cover the UK. Now, in both of those cases, you're automatically going to be given a corresponding right in the UK by the UK government, and that will come into effect immediately on the 1st of January next year. So there'll be a continuation of the protection for everyone with a granted and registered right. For people who have pending applications to get a registered design or a registered trademark, if it hasn't granted before the end of the year, you'll be given a short period of time in which you can reapply in the UK as if you'd applied in the UK the day you did so in Europe. So you can see that the government is trying to ensure that there's continuity of protection for businesses here. But as of next year, you're no longer going to have one universal right that covers the whole of the EU. You're going to have a UK version of it and an EU version of it. You might find that you're not using your EU version, in which case you can license it out. And likewise, a lot of EU companies might find they're not using the UK version. It's also going to be impossible to get a infringement remedy that covers the whole of the EU. So at the moment, if I find somebody who is infringing my registered EU design, I can get an injunction that prevents any sale of the infringing articles across the whole EU. But as of next year, I'll have to do that separately in the UK and then also in the EU, because that won't carry over to cover us. There are lots of intricate ways in which Brexit will have ripple effects in IP. We don't really have time to discuss them in detail now. But if you do have any questions about that, please feel free to type them into the chat bar. And with that, with a couple of minutes to spare, we now have time to take any questions.
Thank you, Greg. It was a fantastic presentation. Thank you so much for your inputs. Now, may I call my colleague, Murat Islam, to look after the question and answer session, and he will be taking questions from the audience and asking them from Greg. Murat, are you on?
Yes, I'm on. Can you hear me, Ram?
I can hear you. That means everyone else can hear you too.
Perfect. That's great. Thank you very much, Greg, for this informative talk about patents, designs, trademarks, and even the impact of Brexit on our IP rights. I really enjoyed this presentation, really, so thank you for this. I think you touched on it quite in good detail, actually, good amount of detail, and the timing was perfect, spot on. I didn't get many questions, but I created my own questions because I'm quite interested in the topic myself, actually. So can I ask you, why should I get a patent and not a registered design if they similarly deter others from copying designs or products?
So the answer is a good question. The sort of underlying motivation really is whether your product is a functional thing or an aesthetic thing. So if you have something that's of a technical nature, I would generally recommend a patent. And if it's more just kind of the way the thing looks, I'd recommend a design. Patents are perhaps a better form of protection because they're investigated in detail, they're examined thoroughly by the patent officers, and so when a patent is granted, it has a presumption that it's valid. And that's a big deterrent to infringement because it's already withstood some serious testing from the examiners. Now, with a design, obviously, you don't have any of that examination stage. So if someone sends you a letter saying, oh, look, you infringed my design, it may be the case that you do infringe that design, but you take it less seriously than a patent because you then need to go and establish, right, okay, let's go and have a look at the prior art. Let's see if this design really is valid. But for a patent, there's an assumption that it will already be valid. I think patents as well, they're a bit more objective in the protection that they give you because how a patent provides protection is through the claims at the end. So that's this series of sentences. And that will cover anything, regardless of how it looks, what it does, provided it falls underneath the meaning of those claims. Whereas the design only protects the way something looks. So it's a bit fuzzier. It's hard to judge objectively whether something creates the same overall impression. Whereas a patent is clearer to delineate exactly where you say your protection starts and ends. So on balance, I would probably go down the patent route. But you'll need to consider whether you're looking at functional features or stylistic features. And for many, many of my clients, we do both of them. We protect as much functional as we can, and we also go, right, for an extra couple of £100, we can get a design that covers this too, just to kind of shore up the aesthetic angle of it as well.
Yeah, makes sense. So actually, patent is much more of a deterrent than a design. So if your competitors say are keen to retract your patent or design, they would probably pursue if it is a design in that case, actually. Okay. Georgina Harris is asking, what is the most challenging case you have had without giving away any trade secrets?
What's the most challenging case I've had? Well, I suppose a lot of my job is drafting patent applications, meeting with inventors. So sometimes you get an inventor who's had 400 ideas and you just need to try and condense them all down and find something that unites them together as a single kind of concept. So that can be quite challenging. I would say that most of the challenging aspects of the job are when you're looking at freedom to operate and infringement. So I work with a number of clients who are developing their products and they've got competitors that they don't have a very good relationship with. They need to make sure that they avoid their competitors' patents, but you read the competitors' patents and the language is a bit unclear. You're not quite sure what you need to do to avoid it. You have to do a lot of searching for prior art to try and invalidate it. You have to advise your client how to get around it. And those pieces of work can often be extremely complex and extremely involved. I do really enjoy that kind of thing because it's really where the rubber meets the road in my field. It's where you're really adding value to your client by guiding them through the legal system. But yes, as the question says, we probably can't go into any specific detail. But I'd say that in general, the freedom to operate things are the biggest head scratches that we deal with.
Right, right. Okay, I will ask another question. Can I register a patent or a protection based on a material, such as steel versus aluminium versus plastic?
Yeah, I mean, material is definitely something that's patentable. You'd end up. A lot of my colleagues, for example, are chemists or metallurgists or chemical engineers. A lot of effort goes into material compositions. You can write a patent claim that simply says, I claim this molecule or this range of different molecules defined in a particular way. And you can write a patent claim that says you claim their use in a particular field. So, you can definitely patent materials. The key bit in the world of material science, and this is coming from slightly from an outsider's perspective, because I don't tend to do this sort of thing, is that you really need to make sure that you disclose how your material is made correctly. So there's a lot of those problems I said before with, making sure it's sufficiently disclosed and making sure you tell the public enough about it. Because if you don't do that, your patent could fall down. And with things like materials, they can be quite hard to make. Compare that, for example, to, if I did a new design for a toaster or something, everybody can picture how a toaster is generally made. But the process that you use to make a material with a very specific property, you're going to have to disclose that, and you're going to have to do that in detail.
So what happens then if you consider not making of the materials in chemistry kind of things, but actually the use of material in a design? So instead of people using steel for that kind of a design, we are proposing using a different material in that design. So is it patentable in that case?
Yeah, absolutely. So you could come along and say, so a carbon fiber might be an interesting one here. So, whether you can make, you found an object that already exists, you apply a new material to it and you get an improved property out of it. And that improvement was surprising. That's something that's definitely patentable. And in that case, you can claim the object. So you could claim, say, for example, it was, I don't know, a shelving unit made out of carbon fiber. You could write a claim that said, I claim a shelving unit. It has a base, it has sides, something to fix it to the wall, and the whole thing is made out of carbon fiber. That would definitely be protectable, provided that use of the carbon fiber in itself is some kind of contribution over the object, the base object in the art. So there needs to be some kind of improvement, some kind of surprising effect or advantage that using that new material is. If it's just, everyone else does this in aluminium, I'm going to do it with steel, but that's kind of, whatever you might think of doing that, then you probably won't get patent protection for it. But if you're using an unusual material, that's definitely something that you could consider.
Okay, thank you. Another one, what is the time scale between patent pending and actually patent being awarded, granted?
This is almost an embarrassing question. So it takes a long time. It can take a long time. The fastest that I've seen that done is 9 months, but you have to request all sorts of things from the Patent Office. A general patent application, you file it, you get given 12 months to file in other countries, 18 months from the filing date, it gets published, 6 months after that, so 2 years, you have to request examination, and then that will sit with the Patent Office for however long it takes them to get around to it. So some patent offices have extremely long delays, other patent offices don't. You can do certain things to move your application to the top of the pile, or you can do certain things to delay your application to move it to the bottom of the pile. It might not be in your interest to actually get the thing granted quickly. You might be looking at what a competitor's doing and thinking, I'm going to keep my options open so I can make sure I cover them. There's all sorts of reasons. In general, I would say for a UK patent, you're looking at around 4 to 5 years from filing it until it gets granted.
I can see why it's embarrassing.
That's not even bad, I'm afraid. There are other patent offices that are much slower. A lot of that is tied up just in procedural things. Like often you're sent. So when the patent office give you an examination report, sometimes you can be set a deadline that's 6 months long to respond to that. So there are long lead times on these things, and yeah, it's not a fast process. You don't get them overnight.
Excellent. Okay, another question. What is the best way to work with a company that is my competitor in some fields, but could be a valuable collaborator in other areas?
That's a really interesting question. Well, I suppose you can look at a kind of the IP. You'd have to take stock of the IP that you have in the competing field, and then the IP that you have in the non-competing fields. Like, I'm sure there's plenty of companies. In fact, I know some of my clients do it where, particularly with conglomerates, really it's individual business units that are at loggerheads with one another. And then at the same time, one of them is your customer or one of them is your supplier in another business unit. I think it probably depends upon the value of the IP and the market, the value of the market in the competing area. But it could definitely be a good thing that you could use to try and diffuse any problems. So, if you reach a point where you can't avoid one of their patents in the competing field, you might be able to try and leverage something in your non-competing field to help them with and kind of give them some IP, because that they're going down a certain route and they might be able to benefit from something. Other alternatives here are joint ventures. So to kind of nullify the entire thing, sometimes companies will just do a joint venture in which, the supplying company will probably do most of the IP, but really the joint venture is there to make sure that the other side, are not going to sue you because you're kind of both in it together. But yeah, all of those things are really interesting commercial decisions. But, I suppose an underlying factor is that it's important to make sure you've got the IP tools in your arsenal to go into those negotiations and those meetings, knowing what you can offer and what you might expect to get from the other side as well.
And get some leverage behind before you start the discussions and negotiations. Yeah.
Absolutely. Yeah.
Another question here is, what are the costs associated with data protection, IP protection?
So the cost of IP in general, are we saying here?
I would say so. I think that's what they implied.
Okay, so for it depends on the kind of right. Obviously, we've got these unregistered ones which are, clearly free. Patents are the most expensive, I'd say. So the cost to file your patent application at a patent office is likely to be around the sort of £6,000 to £8,000 plus a VAT mark. Every time you go to another country, you're probably looking at another £4,000 to £6,000. If you're going abroad to places like China, you're going to need to get the whole thing translated. So a lot of the costs become paying translators to do things. So patents can be quite expensive. I would say that to file a patent application in the UK and to bring it through to grant is going to cost you at least £10,000, probably towards £20,000.
Right. Is that right, that you can actually get the patent protection for, say, 5 years and then just repeat it if you feel like it is necessary to repeat it? Renew it.
So
is that
what you do,
and spread the cost somehow?
So really, the costs are quite lumpy. The costs are going to be going mostly to your attorneys, your lawyers that are writing it for you, and they'll be weighted towards the different procedural stages. So there's a big upfront cost to write it. There's a big upfront cost when you're filing applications in other countries because of the deadline for that. Then the costs start to trickle out after that. When the patent office sends you a letter that you have to respond to in detail, that might cost you £2,000, £1,000 to respond to it, because you need to review it, make sure that the understanding of the law by the patent office is correct, etc., etc. So it does get to be quite lumpy. In terms of kind of the renewing aspect of it, in some places you have to pay renewal fees every year for your patent application, so you have to do that for the European Patent Office. In the UK, you don't have to pay renewal fees until the patent has granted. So when it's granted and it's out in the market, you then need to pay the patent office a few £100s a year to keep it in force. So, there is an ongoing kind of cost consideration with these IP rights. Looking across to designs, they are registered immediately. It's an upfront cost, but it's quite a low upfront cost. And then they are renewable in terms of 5-year periods. So you get the first block of 5 years, and at the end of that time, you pay a few £100 to the patent office, and then they'll give you the next 5 years, and so on and so forth. But for patents, that's every year. Yeah.
Yeah, quite significant difference there, isn't there?
Yeah, there is. Yeah.
Okay. I've got 2 more questions here. Probably timing will be perfectly fine for both. What happens if you develop an idea and create dated records, but somebody else files the patent application before you? If you prove you have early records of the invention, can you challenge their application later and file your own patent?
I'm afraid in that situation you've been beaten. It's the first person to file. Now, a key consideration here is that the way a patent is judged for its validity is based on whether something was disclosed before it. So you might have developed your invention and kept it quiet. You might have filed a patent application and then you discover that someone else filed a patent application a month before you. But those patent applications aren't published for a good 18 months after they're filed. So it takes a while for you to actually find out that someone else has got something in the pipeline. Now, in that situation, there is a little legal workaround, which is that you no longer have to have this inventive step concept. You just need novelty. So provided your claims as the later application are simply new over what happened with the other person's earlier application, you're fine. You don't need to have also an inventive feature. So they lower the bar very slightly for you. But essentially, it's up to you as the inventor to get your application on file as soon as you can, because there isn't this kind of concept that you can invent it and then kind of sit on the invention for a while. That definitely used to be true in the United States until 2013. They had that system, but they were the only people that ran it that way, and they've gotten rid of it now. So yeah, you've got to get filing first.
Okay, makes sense. The last question is a different kind of question. What would you advise to engineers considering a career in the patent office?
Sorry, what was the question again?
Question is, what would you advise to engineers considering a career in the patent office?
I suppose one thing to sort of discuss here is that so I don't actually work in the patent office. I'm just a patent attorney. So patent examiners are a different group of people. So they are people like engineers who have a similar background to myself that work in the patent office itself. It's a very good career. You spend a lot of time learning about new technologies, new different ways of doing things. You become an expert in certain fields. If you're interested in it, I would definitely have a look at the patent office's website, or if you're interested in becoming a patent attorney, I would have a look at the Chartered Institute of Patent Attorneys online. There's loads of guides up there for people who want to get involved in the career. I've certainly found it, a really great career. I'm always learning about new technology. I'm always meeting inventors and keeping up to date with the things that they're doing. I've dealt with some fascinating cases. You're solving puzzles every day and coming up with innovative ways to help your clients around certain problems. And sometimes you're even doing a little bit of the designing. You're telling them how to do something, or have you thought about doing it in this other way? So it can be a great career. If you're interested, definitely go online. There's tons of resources that'll tell you more about it.
Fantastic. Thank you very much, Greg. It's been a really good session here, and I'd like to thank you for all your effort on presenting this. And I will probably bring this to a close and thank all the IMechE volunteers that helped this event happen as well. Ram Shankar from Equitas, he helped us quite a lot organizing this. Greater Manchester area from the IMechE, they've been facilitating this for us. And I'd like to also thank Fiona Wong from the IMechE headquarters to actually make this facility, make this webinar work for us. So thank you all very much, and have a great day. Thank you.
Thanks, everyone. Thanks, Murad.
Thanks, guys.